We come now to the last speaker of the official program, which is dealing with not with the mood-related problems, but a problem which is closely related to the mood, and that is the problem of cybersecurity in arbitration and the ICCA Protocol. And we have as a speaker Ricardo Aprigliano. He is the founding partner of the law firm Aprigliano in São Paulo. He is also a professor at the university there, teaching at university, has a law degree from São Paulo and also studied in Florence. So there seems to be a very strong Italian-Brazilian connection here today. He is on the list of arbitrators of all the major Brazilian institutions, including naturally the CAMS-CBC. And he has published widely in the field of arbitration and civil procedure law. In addition, he is the deputy editor-in-chief of the Brazilian Journal of Arbitration. And it's a pleasure to have you here. Ricardo, the floor is yours.
Well, good afternoon, everyone. It's a real pleasure for me to be here, truly an honor. When you say, Professor Stefan, that I'm the last one to talk about, I should tell you the amazing afternoon that we had so far. It's about to get really worse, but it's 20-something minutes. I'm sure you will be able to wait a little bit. Carlos and Luisa, thank you so much for suggesting my name. And we are going to talk about cybersecurity, and there is a kind of a reason that this subject is very, very useful nowadays, not only because of the moot. There is a question about the admittance of a buying evidence, and it might be weird to buy an evidence, but anyway, the question, the theoretical question behind it is whether if it's admissible hacked evidence or linked evidence. Anyway, cybersecurity is broader than that. And I'll start by asking you some things, because as we get aware of this issue, we have to consider that we are part of the solution and we might be part of the problem. So, a fast quiz. I'm not asking you to raise hands. I just wanted you to take a look at these questions. Have you ever wondered what kind of practice does your client have when it comes to communications with you? Do you know how your client keeps your files? Do you know how an arbitration institution keeps your files? Do you know what your office is doing? What about training, technological training? What was the last time you got in touch with IT guys and they were advising you about, I don't know, free Wi-Fi airports, about encryption of emails, about backups, about the 1, 2, 3, 4, 5, 6 passwords that you still have in some of your devices, or your, I don't know, your birthday on your bank account? Have you ever, or have you recently talked about these kind of issues? So, cybersecurity is pretty much about this. And I thought about these questions because they are things that we don't have to talk about how CAMS-CBC is dealing with it, or ICC, or this. We have to think about how we are dealing with it. Because as Eric has just said, when, for example, in a conference, in a remote conference, everyone is part of a potential problem. So security has to be everywhere. Because if I'm very secure, the methods that I use are very secure, but yours aren't, we might be in danger equally. Okay. So cybersecurity is about security breaches, security attacks, and unlawful access to information of an arbitration proceeding. There is a story a few years ago, PCA proceeding was hacked, and during a hearing, there was everyone who was trying to access a website, the website of PCA, were hacked without knowing, and that happened because of a simple problem, not really technological complex, but something was not updated and allowed the hackers, the crackers, to install a malware in everyone's computer who accessed that website, and this became a humorous case in international arbitration. And a few years later, we were talking, and last year we were talking about a draft cybersecurity protocol from ICCA, and they had a period of time with public consultation, and it's ended, but we don't have yet the final version of that new coming soft law. Anyway, we don't need a hacker or a cracker to have a security breach. We only need weak passwords or a forgotten laptop in an airplane or in a hotel, and once again, it comes back to our behavior and how aware of our participation in that chain we are. So what happens? We might have, and here we start talking about some legal aspects of this technological issue. We can have, first one, a problem of breach of confidentiality. So I could say, from an arbitrator point of view, I am really, I have a duty to confidentiality, even if the proceeding is not confidential. I'm not allowed to make public the information of a proceeding. For example, in Brazil, we have our Brazilian Arbitration Act provides that public administration, when in an arbitration proceeding, the proceedings have to be public. So you cannot agree on confidentiality when it comes to public administration, even though I'm not the one who is allowed or obliged to reveal the facts of a public administration. This is something related to the public entity or to the arbitral institution. When you see model law, German arbitration provisions, Brazilian provisions, when you see most of arbitration rules, not only parties, but especially arbitrators are legally bound to confidentiality. So when I simply forget my laptop, or when I wait for a plane and I get the free Wi-Fi airport signal, I might be potentially breaching one of my legal duties as an arbitrator. But when it happens, when a breach happens, we might have some loss of data, and for example, we have PCA, the website went off, but when you go outside the arbitration boundaries and you think about cyber attacks in general, you might think that websites might have to be shut down, and every service provided by that website will be not able to be provided at that time. And when we come back to an arbitration proceeding, thinking about a proceeding that the files are uploaded by links to the website of the arbitration institution. If it goes down and it's the last day to file a memo or to make your pleading, you might have problems with your arbitration, and even though the arbitration itself was, for example, just like Eric said, regular commercial arbitration with no secrets, with no particular secrets, because your arbitration neighbor is a very classified one, and that arbitration was subjected to some cyber attack or whatsoever. So those problems might have serious consequences. Damages, of course, very credibility problem. And when it comes to those sanctions, potential sanctions, it's time to say that this ICCA protocol intentionally does not address these kind of things. I'll start talking about the ICCA protocol in a few slides, but anyway, it's on purpose. They are not, at this point, dealing with who should be held responsible of a breach and what would be the consequences. This is very case-by-case situation, and the purpose of a conversation like that one we are having right now, the purpose of a soft law in cybersecurity is make the community aware that we have to face these problems. We cannot not worry about it. So, as I said, there was a joint initiative, the New York City Bar Association, CPR, and International Council for Commercial Arbitration. They issued a draft of a cybersecurity protocol. When you see the other soft laws, IBA guidelines for taking evidence, party representatives, when you see code of ethics, and you compare it to the ICCA protocol, you will see that this cybersecurity protocol is it's smaller, and in a way, it's a very simple protocol. It's a very simple soft law. They don't tell at that draft anything that we already don't know. They simply put together a lot of common sense in technology by, for example, saying, this is something that should be addressed from the beginning of an arbitration proceeding. This is something that the arbitral tribunal has to address, has to lead by consulting the parties, by adjusting those possible provisions with the arbitration institution. Because, once again, as Eric said, we might have cases that they're not that complex or that expensive, so they don't really need anything extra when it comes to security. But we might have other cases when security is a really important issue. Complex litigation, multi-international situations with traveling, people from everywhere, a lot of law firms involved. So the main purpose of a protocol like that is put together the basic provisions about what to be protected, how to protect, what should be done if something goes wrong, and who should take initiatives on that behalf. Well, moving on. Briefly, what the protocol puts on the table and makes us think about. How much protection do we need? Depends. Is it a trademark common dispute, or is it something really complex Is it related to industrial secrets, commercial secrets? Is it related to a lot of data that has to be protected? For example, health, insurance industry, or financial products. All these factors are going to have to be considered and are affecting the things that has to be provided in terms of cybersecurity. When we think about the truly international nature of these disputes, obviously, when I am participating as a counsel or as an arbitrator in a Brazilian arbitration in my own city with 2 law firms from there, and we don't have to do anything other than going to the arbitration institution, obviously comes CCBC. We don't have to upload sensitive files, etc. Probably our Microsoft or Google's security solutions might be enough. Probably the hacking control systems that the arbitral institution provides might be enough. But it might happen that you are in a really big case or in a really small arbitral institution, and you have to be worried about it. The protocol says something that I think it's interesting. It kind of put the lead in the arbitrators, because they have to be the ones to start talking about it, to start deciding or provoking parties to decide on it. And it is something that called my attention, because actually we don't really see it in general. Generally, we don't talk about technology, about anything related to it. We are concentrated in discussing procedural issue or how to solve the matter in dispute. But nowadays, actually, we have to be a little bit more worried about these preliminary issues. Well, the protocol basically, as I said, it's a very common sense soft law, and so they are worried about things that we also should be worried about. How the data will be transmitted? How it's going to be storage? Where? Who is the responsible? And what about the communications? Because you have communications not only among arbitrators. My email, if it's hacked, some communications that I had with my colleagues of a certain arbitral tribunal might be revealed, might be in danger. But I have also communications with the arbitration institution. Parties communicate with arbitration institutions. You have third-party related. The protocol addresses these people too. They have to be involved. You have to get NDAs from everyone. Maybe you have to check what is the technology structure that your expert has, that your expert witness has, that your fact witness has. Because sometimes they might be collaborating remotely. And if it's the case, all this information, all this data will be digital. So we're not worried about a thief going into your closet to steal some documents. The thieves are you don't see them, and they steal you even the same. Going back to the Moot case, we don't know if the problem there was a hack or someone from the company, someone from the responded that leaked the case. The fact is there is a potential breach of confidentiality. And so in one hand, you have the claimant saying, my due process is about getting access to that evidence. It doesn't matter how I got the information that there is an arbitral award related to this subject. On the other hand, the respondent is saying, this is an inadmissible evidence because of cybersecurity, basically because of cybersecurity. It doesn't matter from the respondent point of view if it was stolen or if it was a breach of confidentiality. Either way, you have legal duties being violated and it's not admissible. But if it was that easy, it wouldn't be in the moot case. It's not, okay, it's inadmissible because you cannot steal evidence or you cannot buy evidence. No, it's not that simple, which brings us, once again, the problem wouldn't be in the moot if the cybersecurity were properly held in that situation. So who was breached the Farlab? No, I don't know the name of the parties. So one of the parties should be more protected than it was. So the protocol also, and when in real life we have also to be worried about how to protect data. And there is a lot of things to do. We can get better in our passwords. We have to worry or to ask about. So I go back to my initial quiz about firewalls, about software, anti-spyware, antivirus. We might have full disk encryptions in your providers, or in that communications, in one case communication, you might have to encrypt some emails and etc. Or those double checks about security. You have original password, and then you had a token, or you get another password from another way. So you try to overprotect data. But when it happens, and people from technology say it's not about if it's going to happen, it's about when it's going to happen. When it happens, the questions that the protocol invites us to address are, you have to decide who must be part of this notification process, who will be potentially affected by those breaches, and you have also to work on and to decide, and in a case-by-case situation, what are the risk, the mitigation risk. Okay, we can obviously think that in some situation we might have insurance, but it's probably not enough to have insurance for those situations. For example, it's kind of related, because when we are talking about this, and the protocol also remembers us, we have to think about what is the applicable law related to the data security situation. If we are in Europe, we have it was issued last year, Global Data Protection Regulation. And for example, there it's written that we have, in a situation of a breach of data, the people involved have to be warned in 72 hours. So, what is the applicable rule in that regard on your international arbitration? You have to go through that. You might have a conflict of law check made by the arbitral tribunal to say we are legally bound for those provisions or for those provisions when it comes to data protection. So the real assessment that has to be done is basically shown in that figure. It's taken from the protocol commentaries. You need bigger security measures if you have a high risk and you have potentially major consequences. This is the degree that you have to think on your case in a community of work, arbitral tribunal, institution, lawyers. Everyone has to discuss that at some point. The problem is, are we discussing that in our cases? I don't think so. And the protocol comes in a very good hour. Okay, it's not even, the final version is not issued, but the question, the problem was already raised. So, take a look at this picture, please, and let's think about where are we in that situation and how much damage can we do in certain situations, despite the fact that everyone else might be real protected. So, in conclusion, I would only say that we have to take real care about how do we store, how do we transmit, and how do we assess those informations. It's a very technological subject. I'm not spending 1 minute of your time by discussing things, technological things. This is something that you really don't want to do. Anyway, we shall, in conclusion, we also have to think that we are not far from being protected. It's just a question of knowing how much we are unprotected and doing maybe very little to get to that protection. Cybersecurity is about, as I said, it's not about a question of if, but when it will happen. So that's just like Professor Carmona said, there's not much to really conclude or to advise, but the question is be prepared. Thank you very much for your patience, and once again, it was really an honor to be here.